Bridging civil and common law traditions, Mr. Maxim Osadchiy has built a career that reflects both London's global arbitration hub and Russia's evolving dispute resolution landscape. As a founder of Osadchiy's Dispute Resolution LLP, he brings over a decade of experience from allied practices such as D’26 and Plimpton LLP and Freshfields Bruskers Derrington LLP, where he represented states, corporations, and individuals in high stake disputes across energy, mining, construction, shipping, and pharmaceuticals. Triple qualified in England and Wales, New York, and Russia, Maxim has acted as counsel in more than 30 arbitrations and sat as arbitrator in over 15 international cases under institutions including LCIA, SIAC, DIAC, HKIAC, and LMAA. His reputation for diligence and accessible advice has earned him recognition in Lexology Index 2024 to 2026 and recommendations in the Legal 500 UK. Beyond practice, Maxim contributes to the intellectual development of arbitration. He teaches at Queen Mary University of London, serves on the editorial board of the Journal of International Arbitration, and publishes widely on commercial and investment treaty matters, including recent works on AI's impact on arbitration. His unique experience with litigation funding further enriches his counsel, offering client strategic insights into risk management and financing. Thank you, sir.
Thank you very much for this kind introduction. I hope I'm audible, and I also hope that you can see me as well.
Yes, sir, you are audible.
Thank you. Good day to you all. It's a great pleasure to be here. I'm very grateful to the Secretariat and in particular to, of course, Mr. Veeragavan for the kind invitation and for the opportunity to participate in this truly remarkable event. As I'm sure many in this virtual audience will know, it often takes weeks, if not months, to put together a 1-hour webinar. So I can only imagine how much hard work, preparation, and advanced planning had gone into this 24-hour virtual event. So I commend the organizers' efforts and well done to everyone involved. In my remarks today, I wanted to focus on enforcement of arbitration agreements and on how the promise to arbitrate is becoming increasingly fragile in this ever more fractured world where litigants are becoming ever more inventive and courts in some parts of the world are growing more willing to flex their judicial muscles and to interfere with the arbitral process, often on parochial and highly questionable grounds. Late Professor Emmanuel Gaillard, in his 2020 lecture in Washington University entitled 7 Dirty Tricks to Disrupt Arbitration, canvassed various ways that parties use to disrupt or altogether frustrate the normal functioning of the arbitral process. In his remarks, Professor Gaillard observed that the history of arbitration had seen many attempts by recalcitrant parties to disrupt the proceedings, and that the imagination of those parties seems to be unlimited. On a more positive, optimistic note, he did observe back then that these incidents of obstruction were very much at the margins of the system. They were not mainstream. Now, to be fair to Professor Gaillard, and with full appreciation of the value and depth of his remarks back then in 2020, he hadn't seen much. What we have seen over the last half a decade or so is an unprecedented rise of attacks on arbitration agreements. One immediately thinks about the Lugovoy law in Russia that permits courts to assume jurisdiction over disputes covered by an arbitration agreement due to access to justice concerns created by sanctions, and to then decide that disputes on the merits, sometimes in disregard of the substantive law chosen by the parties as well. Well, you may think Russia is probably a special case given what's been happening since February 2022, the large-scale imposition of sanctions by the West and other countries and various other factors. And there is therefore no basis to say that arbitration agreements are now any more in peril, any more in danger than before. Well, I invite you to think again. We have also seen courts of various European countries setting aside or refusing to enforce otherwise valid arbitration awards on the basis that the underlying arbitration agreements were apparently no longer compatible with EU law. So they were compatible before, but they ceased to be compatible with EU law post-ACMEA decision of the Court of Justice of the European Union, which was later extended. The rationale of the decision was extended to Energy Charter Treaty, to which EU is a party thanks to the Comstroy decision. We have also seen declarations of incompatibility from various courts of European member states, including Germany, saying that claims in intra-EU arbitrations were inadmissible for lack of valid consent to intra-EU investment arbitrations by EU member states. I think now is a very good time to remind ourselves what states are actually required to do when it comes to enforcement of arbitration agreements, not as a matter of policy, not as a matter of their parochial domestic interests, but as a matter of foundational instruments such as the New York Convention and the UNCITRAL model law. And as part of that discussion, I suggest we consider the obligation of states to refer parties to arbitration, and more specifically, the specific and exclusive, as I will come on to explain, grounds on which national courts parties to the New York Convention may refuse to do so. The starting natural point in any discussion of enforcement of arbitration agreements is, of course, the New York Convention. Specifically, we're looking at Article 2, and many of you will be familiar with the language of this provision. Article 2.1 of the Convention imposes an obligation on each state party to the Convention to recognize an agreement in writing, as defined later in that provision, to submit disputes to arbitration concerning a subject matter capable of settlement by arbitration. Article 2.3 of the Convention imposes an obligation to refer parties to arbitration when seized of an action which the parties agreed to submit to arbitration, unless, and that's the critical bit, unless the court finds that the arbitration agreement is null and void, inoperative, or incapable of being performed. So the Convention in Article 2 contains a mandatory referral mechanism whereby national courts, when seized of the matter, shall, not may, shall refer parties to arbitration unless one of the three grounds set out in Article 2.3 are engaged. Again, null and void, inoperative, or incapable of being performed. Now, the same formula, almost verbatim, is found in Article 8 of UNCITRAL model law, and known model law jurisdictions like Switzerland, France, and the United States, they also adopted and follow the same formula in practice. These grounds are exhaustive. Put differently, and I cannot emphasize this enough, courts must refer disputes covered by an arbitration agreement to arbitration unless one of these three grounds can be established. And I suggest we now look briefly at each of these grounds to understand very clearly what they actually mean, to also understand what is the exact basis on which courts, as a matter of the New York Convention UNCITRAL law, may decline to refer the parties to arbitration. Starting with null and void. Article 3 of the Convention doesn't tell you the legal standard for determining whether an arbitration agreement is null and void, but we have had over the years some very helpful guidance from courts across the globe. In the United States and England and Wales in particular, courts have defined that expression null and void to mean devoid of legal effect. And in practice, they have applied an international standard of contract law defenses. In the States, for example, there's a well-settled case law. Courts have ruled that null and void grounds mean standard breach of contract defenses that can and should be applied neutrally on an international scale, such as fraud, mistake, duress, and waiver. Just as importantly is the spirit underpinning or philosophy, if you like, underpinning the application of this standard. So in applying these international standards, in looking and in interpreting the null and void formula, the US courts have repeatedly adopted a narrow interpretation in light of a general policy of enforceability of agreements to arbitrate. With many interesting decisions, but just one example to give you, in one case, courts dismissed the argument that the arbitration agreement was void and unenforceable as contrary to public policy of the United States on the basis that this defense could not be applied neutrally on an international scale. And moreover, these local public policy concerns does not outweigh the policy favoring arbitration. Then moving on to the second ground on which a national domestic court can refuse to refer parties to arbitration, and that is when the arbitration agreement is inoperative. This, again, is not self-explanatory, nor on its own, nor in comparison to the other two grounds for impugning the otherwise valid arbitration agreements. Professor Jan Vandenberg, the world's leading authority on the New York Convention, in his seminal book on the New York Convention Arbitration, 1958, offers the following explanation of the inoperative ground. And he says the word inoperative can be deemed to cover those cases where the arbitration agreement has ceased to have effect. And the ceasing of effect to the arbitration agreement may occur for a variety of reasons. One may be that the parties have implicitly or explicitly revoked the agreement to arbitrate. Another may be that the same dispute between the parties have already been decided in arbitration or court proceedings. In other words, on res judicata grounds. Professor Vandenberg goes on to give other examples, for instance, where the award has been set aside or where there is a stalemate in the voting of the arbitrator, so the award has not been rendered within the prescribed time limit. So that's the ambit and the scope of the inoperative ground as clarified by Professor Vandenberg, and as has been applied fairly consistently across the globe. And then last but not least, you have the incapable of being performed language. And as to this ground, Professor Vandenberg is of the view that it would seem to apply to a case where the arbitration cannot effectively be set in motion. It can be because the language of the clause is too vague, or perhaps other terms in the contract contradict the parties' clear intention to submit the dispute to arbitration. He suggests that if an arbitrator specifically named in the arbitration agreement refuses to act, or if an appointing authority refuses to appoint, it might be included or concluded that the arbitration agreement is incapable of being performed. Although one should mention that it can still, in those circumstances, be salvaged depending on the national legislation. If we are in the model law country, we have Article 11 that helps you with the constitution of the tribunal in those circumstances. So in similar vein, and interpreting this language in the same spirit, Indian court, relying on Section 45 of the then Indian Arbitration Act 1996, which mirrors Article 2.3 of the Convention, said that the phrase incapable of being performed signifies, in effect, frustration and the consequent discharge. If after the making of the contract, the promise becomes incapable of being performed due to unforeseen contingencies, the contract is therefore frustrated. Now, with this hopefully more advanced and clarified understanding of the three specific exclusive grounds on which the court of a contracting New York State may refuse to refer parties to arbitration, just a few observations based on this cursory review. First, as I mentioned, these grounds are exclusive. Courts would be in breach of their obligations, well, of the state's obligations under the New York Convention if they were to refuse to refer parties to arbitration on any other grounds. What also can be seen from this cursory review of the grounds and how they have been interpreted by domestic courts is that they are to be interpreted narrowly and, just as importantly, to be applied in the spirit of general policy to enforce arbitration agreements on an international scale. Remember the US decision I already referred to, in which the court said, yes, we have certain domestic concerns. You say they are of public policy concern, but we also have a very important policy in favor of arbitration, and that policy outweighs the particular concerns the litigant was advancing in relation to domestic US public policy in that case. What then happens in practice increasingly in certain parts of the world, and my suspicion or fear is that we are witnessing more and more courts departing from the language of the New York Convention, from the letter, if not the letter, then the spirit of these three grounds, and doing what they feel is best or what they feel they should as a matter of parochial, primarily domestic considerations. Going back to Russian courts again, well, one would have thought that when faced with a request to refer parties to arbitration, considering whether or not an agreement can or should be enforced, there will be at least some reference to the New York Convention. And yet, at least in the vast majority of the Lugavo law decisions, I haven't detected clear references or any meaningful discussion of the New York Convention grounds. Instead, Russian courts rely to a specific procedural provision. It's Article 42481 of the Arbitration Procedure Code. And on the basis of that provision, they say that the agreement has become, well, effectively unenforceable. They are not saying it's null and void. The majority of the decision saying that it has become unenforceable, and therefore state courts may and should assume jurisdiction and can resolve that dispute on the merits. The rationale, as I already alluded to at the outset of the presentation, because parties, Russian litigants, they are unable to obtain access to justice due to sanctions restrictions. Now, I don't think I need to spend much time to explain, specific reasons why this reasoning, why this position does not withstand scrutiny under Article 3 of the New York Convention, even if somehow one can argue that it has become incapable of being performed, and there is that specific ground that is potentially relevant. It clearly is not the spirit of the application of these grounds. Again, remember that decision from the United States. It's not about domestic concerns. It's not about your parochial considerations. It's about international policy favoring enforcement of arbitration agreements. Now, with intra-EU arbitrations and what we're seeing and continue to see in the EU courts, the situation arguably is a bit more nuanced. European lawyers would tell you that the principles of EU law set out and applied in the ACMEA and subsequent decisions, they prevail over the obligation in these circumstances, state to enforce the arbitration agreement. At the same time, many international lawyers would tell you that EU law is not international law, rather it is domestic law. And there is a very well-established principle that you cannot rely on your domestic law principles in order to escape your obligations under international instruments. Therefore, there's a lot to think about. And the net result of all this is that arbitration agreements in both commercial arbitrations and investment treaty proceedings as well are becoming increasingly fragile. Anecdotally, at least, it appears to be more so than before, and depressingly, there doesn't seem to be a very good solution to the situation in which we are finding ourselves in today. So these remarks are an invitation to have a proper, in-depth, critical consideration of this very issue and of the danger we're all witnessing insofar as promise to arbitrate is concerned, and also a reminder to courts and practitioners of the foundational provisions on which the entire edifice of international arbitration at least was built, and I would like to think continues to rest on today. Article 2 of the New York Convention, Article 8 of the Model Law, and other provisions that I discussed. Has arbitration become dirtier? Going back to Professor Gaillard's insightful remarks back in 2020, I think it might have. Certainly in some parts of the world, we are seeing some of the things which had never been deployed before. The question then, are the tools we currently have in civil law, common law countries, other legal regimes, are they sufficient to tackle those attacks, increasing attacks on arbitration agreements? In most cases, in my view, the answer is no, they are not. Anti-suit injunctions can, of course, be efficient and effective in some cases, but often, most of the cases, it's down to where the assets are, and in some circumstances, however willing English courts or courts of other jurisdictions may be to issue anti-suit injunctions to safeguard, to protect the promise to arbitrate, there's only so much that you can do to enforce that injunction unless against a party that refuses to comply with its obligations under the clear terms of the arbitration agreement. So this is global. This is important. This needs to be institutionalized and thought through carefully. And I hope that together one day we'll be able to get it all sorted. Thank you.
Thank you so much, sir. We have one question for you. What exactly would be the impact of sanctions in enforcing the arbitral agreements?
The impact of sanctions on enforcing arbitration agreements will obviously depend on where you seek to enforce your arbitration agreement. If the question is about sanctions against Russian parties, and if you are in a Russian court, then the answer is fairly obvious, and it has become even more obvious today than it was before. The effect of sanctions on the arbitration agreement will be that it will be considered by the Russian court as the agreement that has become incapable of being performed. The consequence of this being the dispute goes to Russian courts and it will be decided on the merits by the Russian courts. As to other jurisdictions, I suspect different legal regimes will provide their own answers to this question. You need to look at the kind of restrictions at play, the extent to which they actually affect the arbitration agreement. But I would say that outside Russia and very few other jurisdictions, think it would be very hard to convincingly argue that the arbitration agreement is no longer valid enforceable, inoperative, or incapable of being performed on the basis of sanctions. We've seen some attempts to do just that in the English courts. They were given a short shrift.
Thank you so much, sir. Another question. Could you provide some light on the drafting of a proper arbitration agreement?
This perhaps is beyond the scope of the presentation. If we have time for this, I'm more than happy to.
We have the time, sir, if you could.
Yes, you start with the core most important ingredients. First being the arbitration agreement must very clearly state or evidence the parties' clear and unequivocal intention to submit dispute to arbitration. So you don't say dispute may be resolved via arbitration. You say shall be resolved or will be resolved by arbitration. That's the first thing. You also have to very clearly define the scope of your agreement, the kind of disputes you wish to submit to arbitration. And there are also other important questions, such as obviously the seat of arbitration. The absence of a seat doesn't make arbitration agreement invalid or unenforceable, but it will make arbitration potentially costly and much more painful for you and your client. So do say, the seat of arbitration is such and such country, bearing in mind again that we are talking about the legal seat of arbitration. Venue, you're going to have hearing wherever you want virtually as well. Number of arbitrators, that is important. Procedure for appointing arbitrators, if you want something different compared to the inbuilt procedures you have in the rules, all these are desirable features. I think two key sort of words of wisdom, if you like, or lessons learned. First is, especially if you don't have enough time, you've got a big deal, only 15 minutes to prepare dispute resolution clause to insert into your sale and purchase agreement of shares. So do not improvise, do not try to be super clever or smart about this. Go on the website of the relevant institution and use the standard language that they offer. That's the first thing. And second thing, again, relatedly, the longer it is, the more complex it is, the greater potentially is the danger that it can be misused or abused in the process, unless it's been very, very carefully drafted and been thought through. There are two very, very helpful sources that can help you with pretty much every aspect of arbitration agreement drafting. First is, I would strongly recommend a D’26 handbook on drafting arbitration clauses. It's free, it's publicly available, it's quite comprehensive. The other is perhaps a slightly older source, but nonetheless helpful, is Freshfield's guide on arbitration clauses. It is available on Clua, I think. Of course, there are other sources, there are other materials, but that should be more than enough for you to draft a robust, valid, and enforceable arbitration clause. Thank you for the question, by the way.
You're welcome, sir. Sir, could you please repeat the name of the book that you had recommended for drafting the arbitration clauses?
The first is D’26 Handbook on International Arbitration. Second is Freshfield's Guide on International Arbitration Clauses.
Okay, so thank you so much.
You're welcome.
Recognizing an arbitration agreement is one end and the enforcement is on the other. Both are extremely distinct. The problem that persists worldwide worldwide is the mindset of non-recognition of arbitration agreements and the habit of filing a set-aside petition before the competent court by the parties. KFCRI promotes that the mindset of the stakeholders must change to honor the arbitration award and to recognize arbitration agreements by the parties itself. Thank you so much, sir, for your insights and your words of wisdom. It was indeed an enriching session. We would love to stay and connect with you in the future.
Thank you very much. It's been a pleasure. Thank you again for organizing, and thank you for all your excellent questions. I think it's a very nice, albeit unconventional way for me to start my Saturday, but it's starting on a very high positive note. All thanks to you.
Thank you, sir.